Hello, everyone, and welcome to the Aspen Author Webinar Series. Today's topic is civil procedure, student engagement, and the pursuit of justice. Before we begin, I have a few housekeeping items to review. The audio for this webcast is through internet only. Please use a headset, earbuds, or listen to the presentation through your laptop or mobile speakers. Second, this is a one-way communication, so you can hear us, but we can't hear you. For any communication today, please use the chat function to the right of your screen. For today's webinar, we will be using a public chat forum so everyone can share ideas and questions with our presenters and other attendees throughout the webinar. And now I will hand it over to Joanne to introduce today's presenters.
Thanks, Neil. Hey, everyone. Thanks so much for joining today. I'm Joanne Butler, and I'm the managing editor for the doctrinal list here at Aspen Publishing. I'm fortunate to be able to work with some amazing legal scholars to develop learning resources for first-year law school students. And I'm honored to be able to introduce you to today's speakers, Howard Erickson and Maria Glover. Howard Erickson teaches civil procedure, complex litigation, professional responsibility, and torts at Fordham University. His research explores the U.S. litigation process, particularly the problem of resolving mass disputes. He is past chair of the Civil Procedure section of the Association of American Law Schools and was an advisor to the American Law Institute's Principles of the Law of Aggregate Litigation. Maria Glover teaches civil procedure, complex litigation, and a seminar on modern litigation at Georgetown University Law Center, where she's also currently the faculty director for judicial clerkships. She was named 2022's National Rising Star in Civil Justice and the Clifford Scholar in Residence at DePaul Law School. Her articles on civil procedure, complex litigation, and civil justice have been published in the nation's leading law reviews and peer-reviewed journals. She's testified before congressional committees regarding class actions, multi-district litigation, and procedural justice measures. Before arriving at Georgetown, she was Clemenko Fellow and lecturer in law at Harvard Law School. Prior to that, she was a member of the Supreme Court and appellate practice at Mayer Brown LLP. She clerked for Judge J. Harvey Wilkinson III of the United States Court of Appeals for the Fourth Circuit. She's also taught classes at Columbia, NYU, and the University of Pennsylvania. Before I turn it over to the presenters today, we just want to get a quick sense of the audience. So if you're comfortable, if you wouldn't mind just introducing yourselves via the chat function, just share your name, your school affiliation, and maybe let us know about how long you've been teaching civil procedure. And then as you guys are providing that information, I'm going to go ahead and turn it over to our speakers. Professor Erickson?
Hi, everyone. Thanks so much for being here. Maria and I are going to try to make this as useful as we can. It's always a delight to be in a room full of civil procedure teachers. So the problem of teaching Civ Pro, the problem of teaching Civ Pro and the thrill of teaching Civ Pro is that students show up in our classroom expecting it to be some kind of dreary slog through a whole bunch of technicalities or some massive exercise in memorizing rules. And our job to some extent is to disabuse them of that, because we all know how fascinating it is, and we all know how important procedure is. And we know that this is the course where the students are going to learn about the pursuit of justice. And we know that substantive legal rights and liabilities don't mean squat unless there is some process by which people can enforce those liabilities. But students don't show up with any intuitive sense of any of that. And so we bring it. But here's the problem. When the students show up thinking that this is going to be a course, thinking that they're going to have to slog through technicalities, they're not entirely wrong. It's civil procedure. It is a highly technical course. And so if you're like me, you actually want your students to learn the difference between intervention and third-party claims and how they work. And you actually want them to understand, why offensive non-mutual issue preclusion can be problematic. And this is technical stuff. And so we need the students to care about the details and to be detail oriented. So Maria and I have spent a lot of time, both individually as teachers and collectively as authors, thinking about how to help students learn each detail of civil procedure and how to get them to care about it and how to get them to engage in it, and how to get them to see that each detail of procedure relates importantly to the pursuit of justice. So the big theme of this session is really going to be that students care about justice, especially this generation of students, especially in this moment of teaching these past few years. There's an opportunity to really grab students' interest. And when I say the pursuit of justice, I'm not only talking about grand matters. I'm not just talking things that make the front page of the news. I mean, justice in real disputes, justice for this plaintiff and justice for this defendant in every variety of case. And I really think the way to grab students with civil procedure, and we're going to talk about it with regard to particular topics, is to help students see why it actually matters. And so it's all about keeping the students' eyes on that pursuit of justice, keeping their eyes on why these procedural details matter in real cases. And once the students have a sense of how each topic matters in real disputes, then they're ready to appreciate how civil procedure relates to the pursuit of justice writ large. So, thank you for joining us. Okay, so the challenge of civil procedure is that it is technical, but our job is to get students to see that procedure matters and that it relates to the pursuit of justice. Now, as I see it, this sort of challenge comes up in virtually every topic in civil procedure. I think almost everything we cover in civil procedure runs the risk of having students roll their eyes and find it boring and technical or overly abstract or overly detailed. And we really have to pitch it at the right level to keep students engaged, get them hooked. Maria and I have come up with several topics that in particular that we want to talk about, okay? So I'm going to talk about how to use the opening class and the closing class to create a kind of arc of the course and make it compelling. Maria is going to talk about pleadings. I'm going to talk about discovery. She's going to talk about personal jurisdiction. But what I would actually ask you to do now, thank you very much for introducing yourselves on the chat. I appreciate it. It's great to see so many wonderful proceduralists in the room. Thanks for being here. I will, but let me ask you now to switch gears and use the chat to nominate topics. It could be I already mentioned or other topics that you find particularly challenging. Things where you think it's hard to get students, and it could be general topics or very specific ones, things where it's hard to get students engaged, hard to get them to care. I'm just going to wait for a few of those to start rolling in. Oh, yeah. Let's see a couple more. And I assume all of you can also see if you click on your chat and if you're seeing the public chat, you see we've got some nominees for the Erie Doctrine. We're happy to talk about that later. Okay, and yeah, claim preclusion, issue preclusion. Yep, and there are concerns about whether we spend too much time on Erie. Absolutely. Okay, I'm going to let those continue to roll, and I'm going to, and discovery in a concise way. Thank you. So I'm going to talk about the first class and the last class. And what we're really talking about here is creating an arc of the course. So your course has to have some beginning, some end. They have to be meaningful. There's nothing more infuriating to students than getting a syllabus with all sorts of interesting topics and then getting to the end of the semester and having the professor say, well, we only got 73% through the syllabus, and so we're not doing these last few topics. And surely there are students who think, well, I know there are students who think, what the hell? Like, if those topics were important, then why are we not learning them? And isn't it possible that the last few topics were the most important ones that we had to build up to? So I really think it's quite important to think about the arc of your course and where you're going to start and where you're going to end. So let's talk about day one, the grand opening. There are lots of different ways to use the first day of class and an opening set of readings for the class. What I want to suggest is that the thing that many of us find tempting, because it's the way we think about procedure, which is to expound upon some grand themes, I don't think you'll find that students actually get most engaged when you do that. Certain students do. They are the students who are most like us, but they're going to be engaged anyway. The ones you're really working for, the ones you have to fight for their engagement, those students are not going to be drawn in by hearing about the grandest themes of due process on day one. What they need to see is a real dispute, because what they need to understand is how process matters. So there are different ways to do this. I used to teach out of a case book that started with pleadings, and Svirkovich was the first big case, and I would use the Svirkovich case, Svirkovich versus Sarima, to help students dig into that dispute and see how process mattered. What I now strongly prefer to do is use a case file. So Maria and I included a case file in our book. It's 15 pages of which goes from complaint and answer and a deposition excerpt and a summary judgment motion and a bit of a trial transcript and an appellate. And obviously we had to vastly compress it to do that. But the idea is, every book starts with some overview of civil litigation. What we want to do is, and we do that as well, but what you want to do is tell the students the overview, but also show them the overview and get them into it, to get them to start seeing how, wow, in that actual live dispute, these procedural steps really mattered to whether justice would be accomplished. And I think there are different ways of getting there. Let me turn to the last class, the last week of class, the grand finale, how you finish up the course. There are a lot of different ways you can finish up a civil procedure course, and I actually think it's quite personal. But one way or another, I think one way or another, you want it to be something that helps students step back, synthesize, so that it all kind of really clicks. So if the most important thing on day one is to grab the students, to hook them by getting them to see in a real life dispute why process matters, I think the key in the last week of class is to get it to all stick, to get it to gel by having them step back and synthesize a bit. And I'll suggest several ways to think about doing that. One is, going back to Erie, one is you can end with Shady Grove. You can end a civil procedure course with this beautiful case about, this beautiful and difficult case about the line between substance and procedure, where you get those beautiful quotes from Justice Scalia about, well, the test can't be whether procedure matters to the outcome, because of course procedure matters to the outcome. And the test can't be whether people forum shop for procedure, because of course they forum shop for procedure, they're supposed to. And as a way to get students to then think back on the entire course, pleadings, discovery, summary judgment, trial, it can be a beautiful way to do it. So that's one option. Another option is to go to procedure and justice. So something like the Concepcion case, where the Supreme Court upheld class action prohibitions in arbitration clauses. And there are other cases that can work for this, where you can really go heavy on access to justice and ways, in that case, ways that prospective defendants try to avoid litigation. But there are other approaches like that, where you can really go deep on the access to justice point. And then another one, which is the way I like to do it now, is to really come to dispute resolution more broadly, and to get students to think in an integrated way about settlement, mediation, arbitration, and to get them to use that as a way to think about the entirety of the civil procedure course, and how the process of litigation under the federal rules or under the state rules, that litigation adjudication process, is just one way to resolve disputes. And there are lots of other ways to design dispute resolution systems. But one way or another, I encourage you to think about that final class as a way to get students to step back and have it all gel and synthesize, so that they can synthesize it. And with that, I'm going to turn it over to Maria.
Hi, good afternoon, everybody. I'm, like Howie, so excited to be in the room with so many proceduralists, and eager for the discussion, and hope, as Howie said, we can be a little helpful in thinking about how we've thought through a lot of these issues, and bat some ideas back and forth with everyone. I'm going to talk about this notion of leading with pleading. So one of the big debates in civil procedure pedagogy, as I'm sure you're all aware, is, do you lead with pleading? Do you lead with jurisdiction? Maybe some others have different approaches, but the dichotomy often is lead with pleading or lead with jurisdiction. I'm not here to tell you how to resolve that. I lead with pleading. Our book leads with pleading, although is cross-referential in ways that one could lead any way they wish. But I wanted to set out how one might lead with pleading, and why I tend to like it, and how I use it to get students interested and hooked, and also to avoid one of the biggest pitfalls of teaching procedure that I've encountered, which is you can really miss the forest for so many trees, but you also don't want to miss the trees because you're only focused on the forest, right? It is granular, it is technical. And one thing I find students struggle with is they kind of get lost in what are we talking about? And I mean a couple of things by that. What are we talking about in the sense of where are we in litigation? And more broadly, even what is litigation? And how does any of this relate to the substantive law? And if anything, students tend to err on the side, sometimes for the first part of the semester. If you don't catch it early, they'll do it for the whole semester, in trying to resolve the substantive question, right? Was the confinement in Iqbal in violation of the Fourth Amendment? Well, fundamentally, that question doesn't get answered. So what I start with in leading with pleading, and I use our case file in chapter 1 to do this, is I give them a roadmap. And it's overly simplistic, but it gives them the puzzle border, right? When I build a puzzle, I'm not talented enough to do the middle first. I do the border first. And that's something bad. That's the hook. That's the dispute. In our case file, there was an injury. A gentleman fell into a ditch that was allegedly poorly lit at a hotel. So something bad has happened. And it's so bad in terms of the dispute resolution situation that parties can't work it out on their own. And that's how we get to pleading. And I put a flag of pre-filing strategy and considerations that we're going to layer in, that we're going to discuss step by step as we go through the course, and we're going to deepen. But everything's going to build on this overall roadmap, and they're going to be able to see connections among things. They're going to see how things get deeper. And then when I get into pleadings, the initial foray into pleadings is the Rule 7, the Rule 8, Rule 9, Rule 12, Rule 15, Rule 11, right? So basically, what is a pleading? When is a pleading sufficient? How do you challenge the sufficiency of the pleadings, either by way of an answer or pre-answer motion? How do you amend your pleadings? What are the ethical constraints on pleadings? And we have some very, new and interesting and very memorable cases brought to us by the Trump administration's challenge of the elections in terms of the ethical constraints and in terms of sufficiency of pleadings. But when we walk through those, they see, before we get into Swierkiewicz, before we get into Twombly, before we get into if you teach at Iqbal, what's at stake and where we're going. What's at stake is that gate. Can you get to discovery, which is often expensive? Can you get past discovery where you're going to narrow some issues and maybe have the judge decide some and take them away from the jury? Are you going to continue and go to trial? And then after that, what are you going to do with the judgment? And that, you can layer preclusion, you can layer all of those things. And then at any time, this could settle. This could settle. I set that all up at the very beginning of class so that even when we get deep in the weeds of plausibility pleading and how we look at different complaints and how we evaluate whether Swierkiewicz's complaint would survive Twombly, and in our book we provide excerpts of the Swierkiewicz complaint in order to do that, before we get into those weeds of the difference between heightened pleading under Rule 9 and plausible pleading under Rule 8, they see the outline of the puzzle. And I promise them that I'm going to plant flags along the way. I'm going to say where everything's connecting. I'm going to deepen this outline. And then at any time, they have to be thinking not only where we're going, but how all of these impact how this could end, either via trial or via settlement. And so if you don't mind, Joanne, going to the next slide, this is just one example of layering on top of that initial roadmap. This is not a fully layered example. It's a small board, and I didn't want to overwhelm the screen. But after we've gone through the litigation process, we go back and we say, hey, remember that a pleading has to state the court's basis for jurisdiction. Remember, we talked about those waivable and non-waivable defenses that you can raise in your answer or by way of pre-answer motion. You know what those are generally, because I give them a very brief introduction. Now let's get into the depth of those topics and let's place them right in our roadmap. You know where you are. They start to feel comfortable. They start to feel, I can do this, because they remember, oh, wait, I know where this comes up. You have to think about this before you file. You have to include it in your complaint. You have to raise the defenses either in your answer or your pre-answer motion, subject to those, mechanics. Now let's really understand what the meat of those arguments would be. What would a subject matter jurisdiction statement look like? What would a personal jurisdiction objection look like? What would the venue objection look like? And I even include Erie here. You've got to take into account what court you're going to file in, given the possible choice of law issues. And something I wanted to respond to that Richard brought up in the chat about horizontal choice of law, I could not agree more. And when Howie and I were discussing what to include in our book, I really made a pitch, and Howie agreed, that we needed a primer on horizontal choice of law, not just because it's hard to understand Erie without it, but because it's so darn important in its own right. Conflicts of law classes are increasingly rare, and even if they're not everyone's going to take them. To be clear, our book doesn't exhaustively do horizontal choice of law, but it provides a primer on what horizontal choice of law is, why it matters, and what the basic approaches are. I go through that. So when you're thinking about what court to file in, you layer that on top of what you've taught in pleadings with regard to sufficiency and what's required to be in the pleadings. Okay, well, what claims are going to go in your pleading? You've thought of that from the perspective of sufficiency and whether they're plausibly pled or whether they meet the heightened standard under Rule 9 if it's for fraud. But what claims might you choose as a matter of the court you want to be in, as a matter of whether the court's going to have jurisdiction? What kind of claims are you going to include depending on what parties might be defendants to those claims or who might be impleaded based on those claims. That layers on joinder, also layers on Erie. So all of these things kind of layer on one another. And one thing I find great about leading with pleadings and the case file is they have the puzzle border. They have that puzzle border. They have the basic idea of what litigation is, what it's about, what tools are available, what the mechanics are of making these arguments. And then, at least, and from my view, a little bit later in the course, they're ready for you to explain that, hey, personal jurisdiction's fundamentally a common law set of developments. It's going to track things you've been studying, contracts, in torts, at least that mode of reasoning, and remember where it fits. You've got to put that statement of jurisdiction in your complaint. You've got to respond with your objections in the answer to say like personal jurisdiction. So it all kind of layers. But then on pleading in particular, and I think the next slide just goes into some of the granular stuff, and then I'll take it up a level. I kind of start simply because starting civil procedure is hard, period. If you start with pleading, it's hard. If you start with jurisdiction, it's hard. So there's no easy way in. And students are ready to answer the question, did the Bells conspire to raise prices? Was the Fourth Amendment violated? Was Akis Swerkowitz discriminated against? And you really have to back them out of that. What is a pleading? What is a complaint? Okay, it's your chance to put your facts and the law that makes those facts operational into an official document with the court. And then the defendant has to respond. And so we talk about, the very granular stuff. What has to be in the complaint? And this lays your groundwork and plants your flags for a deeper study of subject matter jurisdiction, a deeper study of personal jurisdiction, a deeper study of venue, a deeper study of service, a deeper study of necessary joinder. But it also allows you to get out very basic things. Who did what to whom? Why do I have a right, allegedly under the law, to pursue this in court versus, some other way? What do I want, right? I have to state my relief. It sort of grounds students pretty immediately in what's going on, what's at stake, who's involved, why it matters, and why we're even talking about court. Then we get into that really hard stuff about sufficient pleading. And I really try to use the sufficiency of pleading as an opportunity to teach a critical lesson very early in the semester. And that critical lesson is this: where does the substantive law figure in a procedural course? It's not irrelevant. We all know it's not irrelevant. But I use the teaching of pleading to hammer home the point that the substantive questions in a procedure course are in service of the procedural question. So the sufficiency questions are, well, what is the standard for whether a plaintiff has made a short and plain statement upon which relief can be granted under Rule 8? What does that mean? Well, as we know from Twombly, it means plausibility. We know from Iqbal that applies to all claims. And so then we get more granular and say, okay, what would the court have liked to have seen in a context of an employment discrimination dispute, in the context of an antitrust dispute? And it's at that point that I tell my students that procedure is hard in part because you have to know a little about every substantive law, but that's also what makes it great. But at that point, I really drive home the point that fundamentally the question isn't, did the Bells conspire? The question is, did the plaintiff state enough facts to get over the sufficiency standard of plausibility to survive that motion to dismiss, to open that gate to discovery that's in their roadmap, to get to that costly discovery that Justice Souter's worried about. That really hammers home relatively early in the course, and I find really helps students not get so confused about what the primary target for their study is. And that's that procedural question. And I really hammer home, what's the procedural question you have to answer How do you engage with the substantive law in order to answer it? So there's a few more granular questions that basically just runs through what you would do in pleading. But I want to go to the next part, which is sort of these big themes that even in the granularity, you're able to go to that add consistency, they add connection, and at least in my experience, really hook the students. So what is the point of all these pleading requirements? Well, one point is access to more litigation tools. You can't get access to discovery, which many plaintiffs are going to need, especially for claims where the information is largely in the hands of the defendant. You have to get over these procedural hurdles to get to those tools. You have to be able to get there. So that's one payoff of learning these granularities. They're not just technicalities for their own sake. They have real payoffs or real burdens if you don't satisfy them. At a higher level of abstraction, it's access to the courthouse. Those pleading standards, whether they're higher or lower, whether they're transsubstantive or not, matter for purposes of whether plaintiffs are going to have access to the courthouse, and to what extent defendants are going to be able to stave off litigation at the courthouse. One level up, at least to the extent we think a given substantive law is related to some form of justice. The exact debates about the given substantive law can kind of occur below this, but fundamentally, to the extent we're trying to effectuate justice by way of litigation, because we don't want to revert to some Hobbesian state of nature, whether or not you can survive the pleading stage determines fundamentally whether you have access to justice as it would be, effectuated by way of that litigation, by way of some sort of settlement, by way of a jury trial, by way of a bench trial, by way of the judge's decision on summary judgment, by way of even being able to investigate your claim. That in itself is a form of justice that connects to the litigation tools. And as I mentioned before, one big thing I really use pleading for is to teach students how to study procedure. They really struggle with this, and we had a lot of students comment on our book as we were drafting it, and I had a great group of students that year, and one of the things that they really talked with me a lot about over pizza was, please help students understand how you read a case in procedure. Not just how you read a case, that's hard enough, but how you read a case in procedure, because there's so much there and we don't know what to focus on. And so I really use pleading to put that procedural question or questions front and center. And then we situate the substantive law. Then we situate those other things in service of that procedural question. So those are kind of the big themes about leading with pleading. Obviously, if you wanted to lead with jurisdiction, that doesn't preclude you from giving a roadmap and then say, hey, we're going to go with these sort of pre-filing questions. Where are we going to file this thing? What claims are we going to raise? Who are we going to include? And yes, there are mechanics for doing that, but we're going to think through first the sort of constitutional and statutory law that we have to think through to make those decisions. That roadmap can still work. The case file can still work. You can just sort of flip the order of how you go through that. So, either way, it kind of works. But I do find it really helpful in the beginning to set forth that puzzle border, to have a point of reference that you can use the whole semester. So that second slide where I'd started to layer, right? You can have a third slide that layers more. You can have a fourth slide that layers more. And then at the end, they have a diagram, they have a checklist, they see how it all fits together conceptually, they see how it all fits together chronologically. And that tends to be very, very helpful. But if you do lead with pleading, I do find that it's really helpful to hammer home these themes, but also to really milk pleading for all it's worth in terms of teaching those really foundational lessons about how to read a case and why this all matters and what's at stake. So with that, I'll end there and turn it to Howie to talk about discovery, which is also very difficult to get them hooked on.
Thank you. I love this chat because I know I am in a room of proceduralists. So I asked, what are topics where it's challenging to get students to care about it, get them engaged, get them to understand it. And so here I'm looking at the chat. We get Stephanie saying eerie, Pooja saying eerie, Maria saying eerie, and then Richard saying, not eerie. It's a mistake to spend too much time on that. And then, right, so Charlie saying Erie's challenging. And then we get Henry with the confession, I've reduced Erie coverage through the years, but always feel guilty about it. And Stephanie ditto. And then Richard making this valuable point about horizontal choice of law. Okay, here's what you have to remember about Erie. So I totally agree with Richard that there was a generation of proceduralists who found Erie fascinating. So suppose you're a proceduralist like me who actually thinks our job in teaching civil procedure is to teach students civil procedure. Like, suppose you actually think that our job is to help every one of our law students go out and be the best lawyer they can possibly be. And for the litigators, the future litigators, they need to get some initial grounding in civil procedure. And for the non-litigators, they need to understand how the civil justice system works, because every lawyer needs to understand that. So if you believe that that's our job and not that we're teaching some sort of political science course called civil procedure, then you can't justify spending massive amounts of time on Erie. Okay, but and if we really cared about preparing them as lawyers, then wouldn't we teach them horizontal choice of law as opposed to vertical choice of law, federal, state? Because isn't that really much more important? And so few students, far too few students, take conflict of laws. Okay, so here's the reason we teach Erie, and the reason I think it's worth devoting, let's say, 1 week to in your civil procedure course, devoting maybe a couple of classes to it. The reason is, at the end of a course in civil procedure, there is nothing better than Erie for getting students to explore the line between substance and procedure. So after they've learned pleadings, discovery, summary judgment, trial, appeals, joinder, preclusion, jurisdiction, and so on, for them then to pause and ask, well, what is it that held this course together? What is it that makes these all a certain kind of adjective law, a course about the process of litigation rather than about the substantive norms that are being litigated? There's something very powerful about that. I think different teachers can use it in different ways, but the reason to teach Erie is to get to Gasparini and Shady Grove so you can do that. And so when I teach Erie, there is very little hide the ball, because honestly, the basics of the Erie doctrine, in federal court, in diversity cases or on state law supplemental jurisdiction cases, apply federal procedural law and state substantive law. It's not that hard. So the basic concept we can do in no time at all. And the only way it gets interesting is really when you're exploring those borderline cases about, like Shady Grove, about what is procedure and what is substance. And what I would suggest is there's something very valuable about that if you want students to synthesize at the end of the course. So the key in keeping Erie short is to be clear about what your goal is. You're not teaching it because vertical choice of law is so important for students to learn. Because if that were it, you could have done it in 5 minutes, and then you could move to the more important horizontal choice of law. No, instead, the reason it's in, well, I'll say the reason it is in our book, and the reason it comes right at the end of the book, just before we then close things with dispute resolution as a way to synthesize the whole course, is for exactly this reason, that it's a look back at all of procedure. Okay, so then there was this comment in the chat here about class actions. Let's see, where someone said, oh yeah, also struggle with how much, if any, class action material to cover. And then Henry said, agree on class action. This was very painful for me and Maria, but because look, Maria is an incredible class action scholar, and class actions form a central part of my scholarship as well. And man, we could have written a beautiful 500-page chapter on class actions, but we didn't. We wrote, it's under 20 pages. It's like in the 15 to 20 page range on class actions because I think there are too many civil procedure teachers who end up skipping class actions because it's all too complicated. And you're not willing in your one semester Civ Pro course or whatever, if you've got 3 credits, 4 credits, 5 credits, you're not willing to devote multiple classes to getting into all the details of class actions. And so you can't assign 100 pages, you can't even assign 50 pages, but you would assign 20 pages. You would take one class session so that students can learn about this thing that is both theoretically fascinating, the idea of representative litigation as an alternative approach to collective litigation, very different from other joinder mechanisms. It's so important for students to learn, and it's so important as a practical matter, both class actions and multi-district litigation. And so with great pain, Maria and I made a very short and sweet section on class actions. So really what I would urge everyone to do is to cover class actions, but do it in one class because you can just get so lost in the weeds. And for the students who really care about it, let them take my complex litigation course or Maria's complex litigation course. Okay, but I want to go to discovery. So what's hard about discovery? A lot of teachers throw up their hands and say, you can't teach discovery to 1Ls. I mean, discovery is something that lawyers learn by doing. We're not going to teach, look, at Fordham, I've got 90 students in my Civ Pro class. The idea of teaching people how to take a deposition or something is ludicrous. Or the idea of my being able to do real drafting exercises and give them meaningful feedback. I can't do that. So you have to be realistic. So with discovery, as with Erie, I would say it's worth a week of your course. It's worth at least a week of your course because as a practical matter and as a conceptual matter, it is hugely important. We all know students cannot understand pleadings unless they then learn about discovery. They cannot understand summary judgment unless they understand discovery. They certainly can't understand trial in the American system unless they understand the role that pretrial discovery plays in the American system. So we have to teach it. We have to teach it well. But you just have to be realistic about what you're doing. You're not, in a large 1L Civ Pro class, you're not trying to teach discovery skills. They will learn that in simulation courses or drafting courses. At least they don't learn it in my class. But they can learn the law as it relates to discovery. But then here's the challenge. Discovery rules are very technical. And if I've decided I can't teach them, I can't do the sort of simulations that really teach them discovery skills, but instead I'm going to teach them discovery rules. Well, that's precisely the sort of thing that's going to make students roll their eyes and lose interest. And so the key, again, returning to the theme, the key is to get out of any mindset of looking at it in terms of here are a number of federal rules of civil procedure, and let's learn about each one. Also to get out of the mindset of here are cases where the courts are adjudicating particular disputes about applying those rules of procedure. And instead to get into the mindset of here is a lawyer who needs access to information in order to serve the client. Here is a lawyer with a client who needs factual information that relates to the claims and defenses. How is the lawyer going to get that information? So that's the shift, and it's hard for law professors because we're so used to the case method, and which has us looking at things from the judge's perspective, and we're also so used to focusing on federal rules of civil procedure. And so to switch mindset is not an easy thing, but it's the key to getting students interested in discovery. So let me mention just a few quick methods. One is when you teach discovery, you don't have to start with your first case on discovery. You can start with a brainstorming, and you don't have to start by going through each of the devices or relevance or privilege. You can start with a brainstorming session. So I like to use the case file we have at the outset of our book. In the past, I used to use Svirkovich. So you walk into the room, you say, and you say to your students, I'm so glad you could make it to our discovery planning session on behalf of our client, James Spar. He's the plaintiff in our particular case file, or on behalf of Roadway Inn, which was the defendant in our particular case file. And let's talk about what information we need and how we're going to get that information. And like that, you get students in the mindset of needing information. Then they start to see interrogatories and depositions and physical and mental exams and requests to admit, and all of that in terms of the need for information, which sounds obvious, but look, it's not how I was taught discovery, and but it's very effective. The other thing is every case. Oh, so if you can, so one time I was teaching a much smaller group for CivPro, and I had them draft interrogatories, and it was fantastic, and it really did help. So if you can do that, that's great. But the other is every discovery case you teach. If you're going to assign several discovery cases, presumably, if you assign Hickman, it's about work product doctrine. In our case, we've got a case called Lee, which is about Rule 37 motions and sanctions. Another one called Howa that's about e-discovery cost shifting. Another one that's about relevance and proportionality. Okay, so as you go to each case, the temptation as a law professor our habit is to go straight into what is the issue that the court's deciding in the case. But with discovery, you just can't do that. You have to start, or at least I would suggest starting, you start with who's suing whom for what, and then you go to who's seeking what discovery from whom, and why do they want it? Like, why do they want this information? And it's only once you do that, once the students understand why someone is seeking the information in this deposition question or in this document request or e-discovery request, once they know why someone wants it, and why is the other party refusing to turn it over, once they get that, then the rules make much more sense and are much more interesting to them. Let me kick it back to Maria. And let's also decide. So I see where I see we've got a little more than 10 minutes left. And so I don't know, Maria, Joanne, Neil, do you have any thoughts on when we want to see if others have questions? I suppose we could just say if people have questions, feel free to put them in the chat as Maria talks about personal jurisdiction, so we kind of know what thoughts are bubbling around.
Sure, and I'll keep personal jurisdiction fairly short for any number of reasons, not least of which, wanted to really get at what's popping up in the chat and make sure we interact with that. And I wanted to echo and build on a couple of things Howie just said that sort of segue a little bit to jurisdiction, but also kind of get at things that help bring discovery to life, but also other doctrines to life as well. So, after discovery in the chronology, at least, if you're following a general path, you go pleading, then discovery, then summary judgment. Summary judgment technically can come earlier, but because of 56D, generally we finish out the discovery of an issue before we move to summary judgment on it. And one way to really bring those two together I find, because one of the hardest things about summary judgment is layering the no genuine dispute of material fact with the ultimate burden of persuasion at trial, with the burden of production on the movement, and then the non-movement's burden, right? It's all very hard. And part of what helps it be less hard is making it concrete by way of reference to discovery. So if you teach Celotex, for example, you could ask, okay, what does Ms. Cotrette have? What did she pull out in discovery? What did she produce? What else might she have wanted to get? How could she have gotten it? How would that have influenced her ability to meet her burden of production? What does Celotex have? Honestly, they don't have much of anything. What could they have gotten? What might you have gone after if you had represented Celotex? And how does that tie in to their burden as the movement? So a lot of these pieces, if you sort of turn it into that, and as Howie said, it seems obvious. So sorry if I'm stating the obvious, but I certainly wasn't taught Supro this way. Who's suing whom for what? What do they want in any given dispute? So there's the main dispute. Then there's the sub-disputes. I want this information from you. You don't want to give it to me. What's your grounds for not giving it to me? And how does that relate to how I'm going to be able to succeed at summary judgment? What I'm going to be able to present at trial if I get there? How it's going to influence when you get to judgment as a matter of law, renewed judgment as a matter of law. So the more I get them brainstorming, and to Howie's point and to Richard's point in the comments, I also have them do sample interrogatories, sometimes sample requests for admissions. They tend to be pretty grateful for that. And it stops well short of a simulation or clinical course, but it gets them in the mindset of, what do I need and why, as a matter of the facts, as a matter of the law, as a matter of my procedural requirements, as a matter of my burdens, and then it all starts to hang together. Personal jurisdiction, I'll just say a couple of quick words since I teach personal jurisdiction later in the course. I've gone through the roadmap. We've gotten through trial and appeals. We've talked about finality and how claim preclusion and to some degree issue preclusion operationalizes finality and balances that kind of open-ended, more equitable approach to procedure with a pretty firm no once we've reached a judgment. I actually say a little bit, and this is in our book, but I understand not everyone does this, about judgment enforcement, just for the simple fact that it's not a foregone conclusion that just because you have a judgment that it'll get enforced. So we sort of talked about that whole roadmap, and now we say, okay, how did we decide what court to be in the first place as a plaintiff? What limitations were there in terms of choosing that court? And then from the defendant's perspective, you in what authority? Honestly, I ask half the class. I make one half the plaintiffs, one half the defendant, and I say, you're the defendant. And your basic question is, under what authority, court, do you have to make any sort of judgment that would bind me? So I sort of situate that overall question, and then I layer it in the roadmap. I make the connection to 12b2, and then that sort of reminds them, oh, this is a waivable defense. So this must be something about what defendants are allowed to raise, but they can waive it. And what does that tell us before we've even started Pennoyer, International Shoe, all of those cases? That starts them in the mindset of, oh, well, this must have something to do with defendants' interests, because one of the hardest things about personal jurisdiction is the shifting values. Sometimes the court seems principally concerned about territorial boundaries and state sovereignty. That's Pennoyer, which then gets resurrected in Nicastro. Sometimes they seem concerned about individual liberty of the defendant, sometimes to the exclusion of all else. Sometimes there's a balance of factors, but just by situating as plaintiffs are trying to figure out what courts could render a judgment, get them what they want, assuming they win, that would be enforceable against a defendant, whereas defendants are saying, wait, which court even has the power to do this? You and what authority? That kind of gets them in that mindset. I tell them sort of in the foundational that this is going to be different than what we've studied so far, in the sense that it's more common law development. It's case by case. We're going to build it through common law reasoning. And then our book separates it this way as well, sort of the categories of where the authority comes from. Does it come from a contacts theory? Does it come from a you're at home in the state, we have jurisdiction over you no matter what theory? Does it come from a theory of consent? Does it come from a theory of property in the state? And that sort of gets them in the mindset of, okay, I'm looking for where that authority is if I'm the plaintiff choosing the court, and I'm looking for whether that authority extends to me if I'm the defendant. So as we walk through the cases, I try to tease out really big themes, which are these underlying values. And again, they sometimes shift and the emphasis shifts over time. And how might that affect how the case is going to come out? And how does that connect to the sources of power? Again, whether it's contacts, whether it's you're at home, whether it's you've consented. And then I make sure when I do that roadmap to kind of connect it to litigation strategy, both about where you'd file, what you would raise in your defenses, what court you would choose, what parties you would include, brings joinder in there. And then one thing about the later cases that really hammers home the access to justice point is throughout procedural doctrine, there's been a lot of use of procedure it depends on your view, right? Prevent plaintiffs from bringing, unmeritorious suits and harassing defendants. And then from the opposite perspective, closing the courthouse doors, perhaps too much. How is the court using personal jurisdiction, or how could you read the court as using personal jurisdiction to open or close or narrow the door to the courthouse? And cases like Goodyear and BMS and Nicastro tend to really hammer home those themes. Since BMS is a class action case, I just want to say one word about class actions and personal jurisdiction, and to echo what Howie said about spending a day on class actions. The students who are really interested, yes, I hope they'll take my complex litigation course, and many do. We tried to put a short section on class actions that was manageable, that just covered numerosity, the basic requirements, defined what Duke said was commonality. Basically, the questions that are apt to drive the resolution of the litigation need to be common. Why do we cover that? Well, it connects to some personal jurisdiction cases. It connects to Shady Grove. It connects to some arbitration cases. But also, I think it's worth a day because so much of the federal docket is class actions and MDL. We're talking nearly half the federal docket. So that's, just one sort of echoing Howie on the class action point, but also connecting to a case that you're probably going to end up teaching in personal jurisdiction, which is Bristol-Myers Squibb, and why laying that foundation in the class action also informs the study of, well, why might the court be pushing back on personal jurisdiction in that case in particular? Well, part of it is because this is a class action that purports to resolve the claims of a nationwide class. I'll stop there. Again, I think lots of people have lots of approaches to personal jurisdiction. And I think that hammering home these themes, really tying it to the strategy and putting it in the roadmap really helps students see it as an integral part of the course as opposed to this separate section in their outline. But I'll stop there and see if we have further questions and things we might want to discuss or anything we might have missed. And I hope that some of this was helpful.
Thank you, Maria. And so I don't see new questions in the chat, but I do want to bring this around to a final thought about justice writ large and the pursuit of justice, not merely for this particular plaintiff or this particular defendant, but in the bigger sense. So look, in the last couple of years, I assume, like many of us, have brought race much more centrally into the course than I used to. I brought COVID into the course in interesting ways. I have brought climate change into the course. Donald Trump was often in my civil procedure course. I mean, there is so much going on in the news, and of course it changes with the news cycles, but to make it engaging, you have to bring that stuff in. But here's what I would suggest. It's not enough for it to be a patchwork kind of thing. It's not enough. I mean, I do it. Like if I'm teaching summary judgment and there is some, Donald Trump case in the news about summary judgment, then I use that as many of us do. But the approach that Maria and I have been talking about this entire time is really an approach where and the approach we've tried to, weave into the book is one where students understand why each detail of procedure matters. They understand why it matters to outcomes. And it's once they get that the other stuff starts to click and makes much more sense and doesn't feel so much just like a patch thrown onto something. And then the final thought in that direction is there's another approach, which is not simply, it's not simply to bring race in because you're teaching summary judgment and you talk about a Section 1983 qualified immunity summary judgment defense in a police abuse case. It's talking broadly about critical perspectives on civil procedure, which I will say I do much more of now than I used to. I think many of us have become much more aware of those perspectives, and students want that, and it's important for them to get it. And again, what I would say is for students to understand that, they have to understand why process matters. So like every which way, I think the grounding is that students actually need to understand offensive non-mutual issue preclusion and they don't need to understand interpleader, but they need to understand class actions and they need to understand depositions and cost shifting and all of that and pleadings and 12b-6. And once they really understand it and get why it matters in real disputes, then you can see how the system as a whole in various ways can entrench injustices. The system as a whole can in various ways enhance the pursuit of justice. And that's what it's all about. Thanks so much for turning out. Neil, Joanne, do we have anything else? Maria?
I would just say that I was both very pleased as a professor and proud of this student for seeing this. I got an email last year at the end of teaching civil procedure from a student, and the email said, "Thank you for illustrating in very real ways that procedure is power, and they who have the procedure have the power, and how that affects everything in our civil justice system." And one way I reinforce that is to sort of highlight how reliant our entire regulatory system is on private enforcement. We are almost exclusively reliant on private enforcement by way of civil litigation or similar to effectuate or not various substantive prerogatives. And so if procedure is power, they who have the procedure have the power. And if the students are getting that out of the course, it goes from civil procedure to, man, I'm glad I know this because I'm going to go out, I'm going to be able to start effectuating these bigger goals. So I just wanted to end with what I thought was a great synthesis by a student I was very happy to receive.
And so Professor Erickson and Professor Glover, I just want to say thank you for your presentation today. I thought it was excellent. I thought we had a lot of great audience interaction throughout. I do want to let our audience know that you can download this PowerPoint presentation by clicking on the handouts tab, and you can download it there off to the right above your chat function. And also, I will be leaving the chat feature open for a few more minutes. So anything that, any questions you may have that you think of between now and in the next few minutes, feel free to put those in. We will get them to our audience, to our authors, and we'll get back to you within 24 hours. And so with that, I just want to say today's webinar has now ended. So thank you very much for attending, and we hope you have a great rest of your day.
Thanks, everybody.